How can evidence be preserved in a premises liability case? In any premises liability case, preservation of evidence early on is critical to the case. The duty to preserve evidence is a requirement imposed by law. Spoliation is the legal term used when evidence is destroyed or lost in light of pending or foreseeable litigation. For example, it is a business owner's duty to preserve relevant maintenance records, surveillance, or personnel communications in a premises liability case. Relevant evidence missing due to the opposing party's bad faith can result in discovery or monetary sanctions, or the jury's adverse inference may be instructed by the court. Regardless, the plaintiff bears the burden to prove its own case. Evidence is lost, destroyed, misplaced, or may even be tampered with. It is best that the plaintiff documents and preserve as much evidence as possible within their own control. The plaintiff cannot rely on any opposing party to preserve persuasive, key evidence that weighs on them incurring legal responsibility.